Hello, good afternoon, and thank you for coming to our CLE on the U.S. Supreme Court decision Dobbs versus Jackson Women's Health Organization from an employment law standpoint. I'm going to start with the introduction of my favorite law professor, Professor Kerri Stone. She teaches employment discrimination, employment law, labor law, and contracts at the FIU College of Law. After receiving a BA in English and Comparative Literature from Columbia University, magna cum laude, Professor Stone received her JD from NYU School of Law, where she was named a Robert McKay Scholar and served as a developments editor of the NYU Journal of International Law and Politics. She has served as a law clerk to the Honorable Michael H. Dollinger in the Southern District of New York, the Honorable Julio M. Fuentes and the Honorable Marianne Trump Berry, both of whom sit on the United States Court of Appeals for the Third Circuit in Newark, New Jersey. Professor Stone was then associated with the law firm of Proskauer Rose in New York, at which time she was appointed to the Federal Legislation Committee of the Association of the Bar of the City of New York. She served as an adjunct professor at Montclair State University's School of Business in Upper Montclair, New Jersey. Professor Stone then became an Honorable Abraham L. Friedman Teaching Fellow and Lecturer in Law at Temple University's Beasley School of Law. Her research focuses on examining anti-discrimination jurisprudence, and her work has appeared or will appear in the Hastings Law Journal, the NYU Annual Survey of American Law, the Yale Journal of Law and Feminism, the Akron Law Review, the Loyola Law Review, the Kansas Law Review, the NYU Journal of Legislation and Public Policy, the Columbia Journal of Gender and Law, and the NYU Journal of International Law and Politics, among other journals. Turning to panelist Kelly Peña. Kelly is an experienced employment lawyer who advocates for clients and provides guidance on a range of issues. She has extensive experience representing employers in connection with a range of claims, including Title VII of the Civil Rights Act of 1964, the Equal Pay Act of 1963, 42 U.S.C. Section 1981, Americans with Disabilities Act, Age Discrimination and Employment Act, Family and Medical Leave Act, the Fair Labor Standards Act, state whistleblower laws, state and local human rights and anti-discrimination claims, and she represents employers in state, local, and federal administrative proceedings throughout the United States. She conducts related investigations, position statements, and she negotiates fair resolutions with a variety of human rights agencies. Turning to Michele Samaroo, she is currently the Deputy City Attorney for the City of Hallandale Beach. She grew up in Miami-Dade County, and for her undergraduate education, she attended Emory University and Barry University, where she was a participant in the university's honors program and received a bachelor's degree in pre-law in 1997. She attended Florida State University College of Law on a full scholarship and received her JD in 2000. She is admitted to practice before the Florida Supreme Court and all courts in the state of Florida. She began her legal career in the Office of the Public Defender in Orange County, where she predominantly handled DUI defense and had the opportunity to successfully try numerous cases to verdict. She has served as assistant city attorneys for the cities of Miami Gardens, North Miami Beach, and Opa-locka, where she drafted legislation and agreements, handled appeals and litigation, and advised on issues related to code enforcement, labor and employment, land use, sunshine law, public records, and prosecuted numerous forfeitures, among other areas. She spent several years as a civil litigator for GEICO, defending personal injury, property damage, and PIP cases, in addition to investigating fraudulent claims. And she's a board certified specialist in city, county, and local government law. And with that being said, Michele, can you please tell us what Dobbs is about? Michele? Okay, so it appears that maybe Michele is having issues with the connection. Professor Stone, in the employment context, what rights do women have when it comes to disparate or discriminatory treatment in the workplace generally?
Sure thing. So I'll kick it off by talking a little bit about the law generally, and I'll stop right up at the point where we get into the law's eventual recognition that pregnancy discrimination is sex discrimination, so that Kelly can do that. And then hopefully we'll get Michele back so we can talk about the opinion and the intersection of the two. Basically, women in the workplace derive most of their rights from Title VII of the Civil Rights Act of 1964. Under Title VII, it is considered unlawful discrimination to discriminate against someone with respect to the terms, conditions, or privileges of their employment because of, and those are the two keywords of the statute, their protected class status. There are 5 enumerated protected class statuses listed in Title VII. They are race, sex, religion, color, and national origin. I'm going to speak mostly about sex, but I'm going to say a couple of words about religion right at the end, just to kind of highlight for you all that that's a potential issue that could arise when you're talking about the Dobbs case and the aftermath of the Dobbs case in the workplace, and I think it's important. But going back to sex discrimination under Title VII, and I will note also that every state has sort of an analog that exists at the state and/or local levels to deal with workplace discrimination because of protected class status, including sex. So keep that in mind as well. But if you're looking at Title VII, there are 3 basic causes of action. One is disparate treatment. That's the basic. The allegation is you treated me differently with respect to privileges, terms, or conditions of employment because of my protected class status. Specifically in this case, it would be because of my sex. The other one is disparate impact. When you're alleging a disparate impact claim, you do not need to show any level of intent or intent to act or intent to discriminate, because what you need to show is a concrete, articulable, particularized policy or procedure that's followed in a workplace that confers a disparate impact on a given protected class. And once that's established, you have your prima facie case, at which point a defendant employer can step in and try to show business necessity. And even then, if they're able to do that, the plaintiff can still come back and show that there is a less obtrusive way of accomplishing the employer's ends without conferring the discriminatory impact. So with that sort of back and forth, the viability of particularized practices can be adjudicated in court. The third cause of action under Title VII is harassment, actionable harassment. And this, of course, started with the recognition of sexual harassment. But now we know we can have harassment based on any protected class status, and even based on protected classes enumerated in statutes outside of Title VII. So for example, the Americans with Disability Act or the Age Discrimination and Employment Act, you can have age discrimination, you can have age harassment, disability harassment, religious harassment, which I'm going to get into in just a second, et cetera. And in order to make out a case for actionable harassment under Title VII, you need to show some of the magic language that's been thrown around is behavior that permeates the workplace environment with humiliation, taunting, ridicule, of course, sexual overtures, demeaning behavior would all qualify. And what you basically need to show is that the abuse is because of protected class status. So in the case of sex, it would mean sex-based. It is severe or pervasive, so somehow permeating that workplace environment. It would affect a reasonable person in the victim's shoes, and it does in fact impact the plaintiff's functioning at work and does impact them negatively. And finally, a basis for respondeat superior agency liability to the chain to the employer. I will quickly just add 2 things before I stop. Three things. One is that, and Kelly's going to pick this up from me, maybe I'll leave that one for last then. What I do want to add is that religion, as I mentioned, is another of the enumerated protected class statuses. And unlike the other 4, religion comes with an affirmative duty on the part of the employer to accommodate. So unlike the other protected class statuses, employers must affirmatively accommodate religious needs of employees that are reasonable requests and that do not confer an undue hardship on the employer. That is an obligation. The failure to fulfill that obligation is considered discrimination. The other thing to keep in mind, of course, is that if you have a public, this is all sort of the legal background, if you have a government job, you do have limited, albeit existent, First Amendment rights. So if you have a government job, you have a limited First Amendment right to free exercise of religion. And of course, there is such a thing as religious harassment, which means same thing, because of religion, severe or pervasive, affects a reasonable person, affects the plaintiff at hand. So when you're talking about debates, judgments, expression of opinions about things that are rooted in religious beliefs, all of this needs to be brought into the conversation. And the final thing that I'll say, just providing that background before Kelly picks it up with pregnancy discrimination, is that the history here is that until the 70s, courts were holding that pregnancy discrimination was not in fact sex discrimination, but merely discrimination against people who happen to be able to or become pregnant, which is, I will now pass the baton over to Kelly to finish us off here and bring us home.
Yes, Kelly, are there specific protections for pregnant women under federal or local civil rights laws?
There are, and thank you, Professor, for that background. It was really thorough and helpful. And some of the discussion regarding religious discrimination, the affirmative duty to accommodate, was bringing up recent memories regarding accommodation requests under COVID, but I'll leave that for a separate conversation. So with regard to pregnancy discrimination, so the Title VII of the Civil Rights Act was enacted in 1964. And then about 8 years later, the Pregnancy Discrimination Act was then created, 1978. And this amended Title VII of the Civil Rights Act to expressly prohibit discrimination on the basis of pregnancy. So prior to that, it was unsettled law as to whether discrimination on the basis of pregnancy constituted discrimination, quote, because of sex, or quote, on the basis of sex. And there were courts that, you know, had differing opinions as to whether that constituted sex discrimination. So once this was enacted in 1978, of course, that then settled that particular discussion. And as time has gone on, there's been a push and pull between the courts regarding the scope of what is considered discrimination on the basis of sex or because of sex. So, for example, LGBTQ discrimination, that only very recently was decided by the Supreme Court as falling under the umbrella of because of sex or on the basis of sex. But what's special or unique here about pregnancy is that it was expressly amended to include this protection here. So what does this mean? This means that an employer cannot subject an employee to disparate treatment with respect to the terms and conditions of her employment on the basis of pregnancy, childbirth, or related medical conditions. And so by extension, and there's also the disparate impact as well. And then by extension, there are also protections in connection with a hostile work environment, as Professor Stone had mentioned. In other words, employees cannot be subjected to unwelcome harassment based on their pregnancy, childbirth, or related medical conditions. And then, of course, there's this threshold standard established by the courts. The treatment has to be sufficiently severe and pervasive, such that a reasonable person would find the environment hostile or abusive. And I will tell you, litigating in the 11th Circuit, that courts here, with federal courts in Florida, it wouldn't be enough for there to be one or two comments to meet that threshold. It would have to be much more severe. There would have to be a lot more going on. The workplace would have to, in fact, be permeated with that type of ridicule and harassing behavior in order to meet that threshold standard. There's also anti-retaliation provisions to consider. So if an employee reports to management or human resources that she is pregnant or being subjected to some sort of disparate treatment or discriminatory behavior in connection with her pregnancy, an employer cannot subject her to an adverse action, such as termination of employment or demotion in response to those complaints or reports. And then with respect to, so that's under the Pregnancy Discrimination Act, but there have also been state civil rights laws, which are patterned after Title VII that have followed suit over the years. And it'll depend on the jurisdiction in which you work or live, how broad the scope would be. So for example, here in Florida, it wasn't until 2014 that the Florida Supreme Court settled it that under Delva v. Continental Group, that pregnancy was considered, discrimination on the basis of pregnancy was considered sex discrimination and was therefore unlawful under the Florida Civil Rights Act. So what this all means is that even though this was settled decades ago, employees filing state law claims don't necessarily have a guarantee that they could seek relief for pregnancy discrimination. They'll have to review the state laws in which they are living or working. But those are the general protections afforded to pregnant women, at least in the employment law context.
So let's go back to Michele. Michele, are you able to discuss what Dobbs is about?
Yes, can you hear me now?
Yes, so happy to hear you.
Okay, great. Okay, so I'm going to give a little bit of the background of the thought process behind these cases. It's a bunch of related cases, so just bear with me while I give a brief history. So in 1965 in Griswold versus Connecticut, the Supreme Court struck down a Connecticut law that regulated contraception and attributed the protection to an amorphous right of privacy, implicit in constitutional guarantees without committing to any one textual source. The Griswold court also emphasized that this right of privacy did not open the door for more aggressive court review of ordinary social and economic regulation. So in Roe v. Wade in 1973, the court found that a woman's right to elect an abortion fell within a heightened protection for individual privacy. The constitutional right to privacy comes from the Due Process Clause of the 14th Amendment. The Due Process Clause does not explicitly state that there exists a right to privacy. However, the Supreme Court has recognized such a right going all the way back to 1891. Just 1 year before Roe, the Supreme Court held that in a constitution for a free people, there can be no doubt that the meaning of liberty must be broad indeed. In Roe v. Wade, the court decided that the right to privacy extends to control over pregnancy. The justice acknowledges that being forced to continue a pregnancy affects physical health, mental health, financial burdens, social stigma. The court created a framework to balance the state's interests with privacy rights, acknowledging that the rights of pregnant people may conflict with the rights of the state to protect potential human life. The court defined the rights of each party by dividing pregnancy into 3 12-week trimesters. During a pregnant person's first trimester, the court held a state cannot regulate abortion beyond requiring that the procedure be performed by a licensed doctor in medically safe conditions. During the second trimester, the court held that a state may regulate abortion if the regulations are reasonably related to the health of the pregnant person. During the third trimester of pregnancy, the state's interest in protecting the potential human life outweighs the right to privacy. As a result, the state may prohibit abortions unless an abortion is necessary to save the life or health of the pregnant person. In future cases, the Supreme Court continued to acknowledge that its heightened protection for privacy rights was a product of substantive due process review, but applied only to fundamental liberty interests. As a result, the court's doctrine required differentiating between fundamental liberty interests, for which the government's interference was presumptively unconstitutional, from ordinary liberty interests, which the government was presumptively free to limit as long as it acted rationally. The justices continued to struggle with the difference between limited fundamental rights and necessary, and rights is fundamental. A narrow test favored by more conservative justices limited fundamental rights to only those that were clearly set out in the Constitution's text or would have been regarded as essential at the time of the 14th Amendment was acted in 1868. A more expansive approach employed in Roe and other cases looked more to a contemporary assessment of fundamental liberties. Roe was upheld in Planned Parenthood versus Casey in 1992. In a plurality opinion, the Supreme Court affirmed the essential holding of Roe v. Wade that women have a right to obtain an abortion prior to fetal viability, but rejected Roe's trimester-based framework in favor of a more flexible medical definition of viability. The decision restated that the source of the privacy right was the due process clause of the 14th Amendment, placing individual decisions about abortion, family planning, marriage, and education within a realm of personal liberty, which the government may not enter. Casey almost moved to an undue burden standard, which makes a law invalid if its purpose or effect is to place substantial obstacles in the path of a woman seeking an abortion before the fetus attains viability. The court extended the same privacy principle in Lawrence v. Texas and Oberfeld v. Hodges, which respectively protect the rights of the LGBT community to form intimate relationships and to marry based on the recognition of an emerging awareness of their equal claim to dignity in profoundly important relationships, notwithstanding the lack of historical protection for these rights. It was in this landscape that Dobbs signaled an abrupt reversal of course. The Center for Reproductive Rights filed Dobbs versus Jackson's Women's Health Organization in March 2018 on behalf of Jackson Women's Health Organization, the last remaining abortion clinic in Mississippi, to block the state's unconstitutional ban on abortion after 15 weeks of pregnancy. The state enacted the ban in direct defiance of Roe and nearly 50 years of Supreme Court precedent affirming Roe's core holding that every pregnant person has the right to decide whether to, hold on a second, has the right to decide whether to continue their pregnancy prior to viability, which are not part of the case before the U.S. Supreme Court. A federal district court granted emergency relief the next day, blocking enforcement of the ban, and in November 2018 struck down the 15-week ban because it violated decades of precedent, holding that the states lacked the power to ban abortion before viability, concluding that the state chose to pass a law it knew was unconstitutional to endorse a decades-long campaign fueled by national interest groups to ask the Supreme Court to overturn Roe v. Wade. The U.S. Court of Appeals, the Fifth Circuit, affirmed the district court's decision in December 2019, writing for the court, Judge Patrick Higginbottom said, in an unbroken line dating to Roe v. Wade, the Supreme Court's abortion cases have established and affirmed and reaffirmed a woman's right to choose an abortion. The state of Mississippi filed a petition for certiorari with the U.S. Supreme Court on June 15, 2020, which asked the court to review the 15-week ban. On May 17, 2021, the Supreme Court announced it would hear Mississippi's appeal. The court issued its ruling on June 24th with a majority opinion written by Justice Samuel Alito. While the court did not reject the concept of substantive due process outright, it rejected any basis for recognizing fundamental rights other than in the text of the Constitution or in deeply rooted historical traditions. Because the right to abortion was not in the text, and because the framers of the 14th Amendment in 1868 did not regard abortion as a fundamental liberty, the court ruled that it was not protected. Instead, the majority found the right to make decisions concerning pregnancy to be an ordinary liberty of the same rank as mundane choices about lifestyle, commerce, or recreation. Under Dobbs, only fundamental rights entitled to strong constitutional protection or liberty so universally respected across time that they would be little likelihood of political interference. The privacy right Dobbs diminishes the right to personal autonomy. A right, as Dobbs put it, is to make and implement important personal decisions without governmental interference. The next rights to be challenged could be those to contraception or same-sex marriage, as Justice Thomas openly encouraged in his concurrence. If these rights are not found in the text of the Constitution and the framers of the 14th Amendment could not have imagined them in 1868, they would not be protected by the reasoning set forth by Dobbs. And as we know, because of Dobbs, 11 states, because of trigger laws by mid-August, had completely banned abortion, and many other states have restrictions on them that are currently being litigated in court. So that's my little synopsis. Thanks.
Thanks, Michele. So, Kelly, given this information on Dobbs, how might protections for pregnant women under the federal or civil rights laws intersect with the decision?
So yeah, this is a complicated issue, right? And that unfortunately, we've got a lot of questions and we don't have answers to all of the questions that we have today. I mean, we're, as this decision was rendered just a few months ago, but there is some information that we do have. So apart from the policy arguments relating to access to healthcare and reproductive rights, One could certainly argue that certain conditions that would prompt an individual to terminate her pregnancy would qualify as, quote, related medical conditions as defined by the Pregnancy Discrimination Act, and would thereby be covered by the Pregnancy Discrimination Act. And further, as the scope of because of sex or on the basis of sex under Title VII has expanded over time to include protections, as I mentioned earlier, for LGBTQ+ employees, it is therefore possible that an individual seeking reproductive health care might fall under this expanding category, but that's as interpreted by the courts. And in light of this, because of sex analysis or interpretations, some agencies, such as the Equal Employment Opportunity Commission, have already construed the Pregnancy Discrimination Act to prohibit employers from terminating an employee's employment based on her decision to have an abortion. And likewise, they prohibit disparate treatment on the terms and conditions of the employee's employment, such as access to promotional opportunities and things of that nature, raises. Federal guidance interpreting the PDA or the Pregnancy Discrimination Act likewise states that if an employer otherwise decides to cover the cost of abortion, the employer must do so in the same manner and to the same degree as it covers other medical conditions. So in other words, there already is some guidance out there in terms of how the Pregnancy Discrimination Act might cover or protect employees who are seeking access to reproductive health care, including abortions or termination of their pregnancies. And a lot of these laws align with the general notion that there cannot be disparate treatment. And then I have to preface this with, I'm not a benefits lawyer, but I can generally speak to the fact that the Pregnancy Discrimination Act requires health plans to cover abortion services in limited cases where carrying a fetus to term would endanger the life of the mother or where medical complications have arisen from an abortion. So these are all ways in which Dobbs is likely to intersect with existing federal laws, right? And then while there have been state laws that have been enacted or triggered after Dobbs, employers ought to be mindful of these federal protections and anti-discrimination laws, and employees may be able to seek relief through these laws. Again, it's still early to tell how the courts will ultimately decide, but these are certainly things to be mindful of. And then lastly, there have been some states that have taken an affirmative step to enact laws that expressly protect the right to abortion or decline to enforce bans from other states, such as California, Connecticut, Washington, and New Jersey. So just another thing to be mindful of in a post-Dobbs world, that some states, in addition to these federal protections, have taken action to provide additional protections for employees within their states. And it looks like I've gotten frozen on the screen. I don't know if you guys can still hear me. Okay, I'm going to just stop my video for a second.
We can hear you.
Perfect. Okay. So that is what I have in terms of the intersection with Dobbs and the federal protections and state protections that we have as of now. So I'll stop there to then move forward on the next question.
So, Kerri, factually speaking, how have employers responded to Dobbs?
Sure thing. That was a great, I think, analysis and really covered a lot of ground, super sharp. Actually, both of you on the facts of the case and what's going on, the implications, and then that legal intersection. As you might imagine, this opinion has created a lot of different thoughts and conversations among different employers. I'm sorry, and so there's the typical, range of opinion that mirrors society that employers have. There are some pretty notable employer reactions that have been noted in the news. Before I get into those, and they've largely, the more public ones have largely been open condemnation of the decision. I think internally, employers are sort of struggling to balance rights. And again, especially with respect to workplace discussion. And I think this is important so that when you have debate, when you have, even conflict in the workplace that stems from disagreements, where those disagreements originate in religious beliefs, employers already noted, tried carefully, they want to create an environment that's free of harassment, of course, that's free of sort of discomfort, bullying, keep morale high. They also want to make sure, especially if they're a public employer, that they're abiding by their obligation to afford free exercise of religion, to reasonably accommodate religion, depending on what that is alleged to consist of in a given situation. So there's a lot of sort of tightrope walking and sort of careful contemplation about how to deal with the issue as it enters the workplace through discussion. In terms of public responses, like I said, there's been a lot of just open condemnation of the decision, and you have several high-profile examples of employers sort of stepping out in front of this and saying, we support our women employees who want to seek medical care. We support their right to privacy. And we have several high-profile employers who are actually providing medical travel, lodging benefits, other stipends to employees who want to have an abortion in a state where it is legal to have one. And again, the caution here, just as Kelly said, I also am not a benefits expert or a benefits attorney. That's not my background. But again, you want to have your radar on, and you want to be aware as you're considering all these issues as an employer that you need to confer with counsel, that you need to talk to those ERISA specialists, that you need to look at the intersection between state and ERISA, state laws and ERISA, with the various abilities of employers do these things, and you want to just have your radar up when it comes to that. In terms of what's been happening in the news, just really quickly, I'll just read you a couple that I've collected. Google has said that Googlers can apply for relocation without justification, and those overseeing the process will be aware of the situation. They said they'd provide travel benefits for employees seeking abortion care out of state legally. The company's U.S. benefits plan and health insurance plan for full-time employees covers out-of-state medical procedures that are not available where an employee lives and works. JP Morgan Chase has said that it's covering costs for employees required to travel further than 50 miles for abortions, among other medical procedures. Airbnb has said its healthcare coverage supports reproductive rights, and they've taken steps to ensure that their employees have the resources they'll need to make choices about their reproductive care. Patagonia, an outdoor clothing company that has deep roots in activism, has gone beyond offering to cover employees' abortion care and travel expenses. They posted a statement to LinkedIn saying that it is offering, quote, training and bail for those who peacefully protest for reproductive justice. Amazon has said it will pay up to $4,000 in travel expenses annually for non-life-threatening medical treatments, including abortions. There's more. The dating app Match offers a travel benefit for reproductive care that may not be available in an employee's home state, and this is managed through the health insurance plans of the company, which it said is completely confidential. And the saying that it put out, the statement it put out, Match Group's reproductive benefits are structured through third parties to ensure privacy and confidentiality for employees. Finally, I found Yelp is a crowdsourced review platform, said that it will not have access, it has stated affirmatively, will not have access to employees' abortion-related travel reimbursement records, stating, and this is their statement, the privacy of our employees was critical to how we would introduce this benefit, which, as noted above, is administered through our health insurance provider, further ensuring confidentiality. Yelp will never receive any information on who incurred a claim and or received reimbursement. So there seems to be a trend of sort of distancing. And again, there are also a lot of employers who either qualify as religious employers for purposes of being insulated from Title VII suits, or who style or fashion themselves or as religious employers who want to take a kind of an anti-choice stance on the issue, and that is grounded in the owners of the company's religious beliefs. So you're seeing a lot of that as well. I'll stop there, but that's just some of what I've collected.
That's excellent. Thank you. And Kelly, regarding the medical travel and lodging benefits to have an abortion performed in a state where it is legal, can you tell us a little bit about that?
Sure. So again, I feel like a little bit of a broken record here, just because this is such a complicated issue. It's new, and employers are still sort of grappling with how do they provide the benefits to their employees without running afoul of, state laws, right? Because no pun intended here, but we're all over the map in terms of, where there's protections, where there's prohibitions, the extent of the bans. So the primary thing that I've seen in terms of what employers have been wanting to do for their employees, those wishing to provide benefits or protections to their employees, is wanting to assist them with either covering the cost of travel in a state in which an abortion is banned, and or covering the cost of lodging so that they can then go to a state in which it's permissible and have their abortion there. So, and just sort of going back a little bit on these bans, there were several states with trigger laws, as Michele mentioned earlier, that were waiting to go into place until Dobbs was enacted. There were some that had certain prohibitions on abortion prior to Roe v. Wade that are now in effect again. I've heard those referred to as zombie laws. And then there's also new laws being enacted altogether. So we have a host across the board of laws, state laws, that employers are having to consider. And in some states, they prohibit it under a narrow set of circumstances, such as ectopic pregnancies, certain medical complications that put the mother's life at risk. And in other states, it's a complete prohibition across the board. And this goes for Alabama, Arizona, Arkansas, Florida, Georgia, Idaho, Kentucky, Louisiana, Missouri, Mississippi, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, Wyoming. So it's a bunch. And as I mentioned, several of them have really, really restrictive bans. Some of them are 6-week bans. Some are 15, and some of it's all together, such as Idaho and South Dakota, where there's an absolute prohibition. So employers that have employees in those states wishing to provide benefits are, again, seeking to either help them with lodging or travel. And what they're doing here is they would provide them lodging or travel to the states that where they're either considered to be surge states, where they've expanded protection or where they have access, such as California, Oregon, or Washington. The one issue they have to be careful with in those instances, we're not aware of any laws at this point. I'm just going to turn my camera off for a second because I froze again, that would prohibit an employee from actually traveling, but there are laws that would prohibit aiding and abetting. So some employers, and they would prohibit that for aiding and abetting or accomplice liability provisions. So this would permit a private individual, for example, from potentially, it would permit a private individual from potentially asserting a claim against an employer who offers to pay for, otherwise reimburse the cost of an abortion, including travel or lodging. For now, that includes Oklahoma or Texas. So even if an employer thinks, well, hey, I'm just permitting them to go across state borders to go somewhere where they're having this done legally, they may still be on the hook and be criminally liable. There is also ERISA to consider here, the Employment Retirement Income Security Act. And again, I'll preface this with, I am not a benefits lawyer, but it should be known that ERISA broadly preempts state laws that, quote, relate to employee benefit plans. And there may be some cases in which it is alleged that the state abortion laws create an impermissible connection with ERISA plans. So that's something to note. Again, we'll have to see how this plays out in courts, but there may be some arguments there that any states that have these abortion bans or prohibitions, that there may be an interference there with their ERISA plan, which would thereby preempt the state law. And then finally, one thing to note is state criminal laws would not likely be preempted by ERISA. So going back to these aiding and abetting laws in Oklahoma and Texas, for example, I don't think that that would be a viable argument for those states. And then just lastly, a disclaimer that employers wishing to offer any sort of benefits for employees in connection with seeking reproductive health care or the termination of their pregnancy, they'll just really need to confer with a benefits lawyer to make sure they're not running afoul of any benefits laws. and I keep freezing.
That's great. We can still hear you, and this is very good stuff. Michele, could you tell us about potential congressional action?
Well, currently, the current president is pushing for Roe v. Wade being codified, and basically the Pregnancy Discrimination Act was actually in response to a Supreme Court case, General Electric versus Gilbert, which extended the concept that discrimination on the basis of pregnancy was not under the Equal Protection Clause of the 14th Amendment discrimination on the basis of sex. So Congress took action in that situation and decided to go ahead and actually codify it to, actually say that it was discrimination basis on sex. Similarly, it wasn't Congress in that case, but and on June 15, 2020, the Supreme Court of the United States issued the landmark decision in the case of Bostick versus Clayton County, which held that the prohibition against sex discrimination in Title VII of the Civil Rights Act includes employment discrimination against an individual on the basis of sexual orientation or transgender status. And President Biden issued an executive order directing all federal agencies to recognize that existing federal bans on sex discrimination protect against LGBTQ discrimination as well. The order was much needed because the prior administration did not acknowledge Bostick and would not enforce the legal protection. So that was a case where both the president and Congress took action in cases that, failed to do something or failed to, or where it wasn't being enforced. And that kind of leads into the current executive order, if you want me to talk about that now, that President Biden signed on abortion in August.
Yes, go ahead.
Okay, so basically it safeguards access to reproductive health care services, including abortion and contraception. It protects the privacy of patients and their access to accurate information. It promotes the safety and security of patients, providers, and clinics, and coordinates the implementation of federal efforts to protect reproductive rights and access to health care. It safeguards access by directing the Secretary of Health and Human Services to protect access to medication abortion. HHS will take additional action to protect and expand access to abortion care, including access to medication. It ensures emergency medical care. HHS will take steps to ensure all pregnancies, patients, including pregnant women, those experiencing pregnancy loss, have full access to the full rights and protections to emergency medical care, including by considering updates to current guidance that clarify physician responsibilities and protections under the Emergency Medical Treatment and Labor Act, which is also known as EMTALA. It also protects access to contraception. HHS will take additional actions to expand access to full range of reproductive health services, including family planning services and providers such as access to emergency contraception and long-acting reversible contraceptives like IUDs. It launches outreach and public educational efforts, and it convenes volunteer lawyers. The Attorney General and the White House will convene private pro bono attorneys, bar associations, and public interest organizations to encourage robust legal representation of patients, providers, and third parties lawfully seeking or offering reproductive health care services. It also protects patient privacy and access to accurate information by protecting consumers from privacy violations and fraudulent deceptive practices. The president has directed the Secretary of HHS in consultation with the AG and the chair of the FTC to consider options to address deceptive or fraudulent practices. It protects sensitive healthcare information. HHS will consider additional actions, including under HIPAA, to better protect sensitive information. It's issuing new guidance on how HIPAA privacy rule protects the privacy of individuals' protected healthcare information. It issued a how-to guide for consumers on steps they can take to make sure they're protecting their personal data, such as on mobile apps. It promotes safety and security it protects patients, providers, and clinics. The administration will ensure the safety of patients, providers, and third parties, and to protect the security of other entities that are providing, dispensing, or delivering reproductive health care. The charge includes efforts to protect mobile clinics, which are deployed to borders to offer care for out-of-state patients. It's also coordinating implementation efforts to ensure the federal government takes a swift and coordinated approach to addressing reproductive rights. They will establish an interagency task force. The president has directed HHS and the White House Gender Policy Council to establish and lead an interagency task force on reproductive health care access. The administration also launched reproductiverights.gov, which is actually reproductive rights. It's just that, and you can look at it, and it provides timely and accurate information about reproductive rights and access to reproductive health care. It includes know your rights information for patients and providers, and promoting awareness of how to access family planning services, as well as guidance as how to file a patient privacy or non-discrimination complaint with the Office of Civil Rights. It also provides administration is providing leave for federal workers traveling for medical care. The Law of Personnel Management issued guidance affirming that paid sick leave can be taken to cover absences for travel. It protects access to reproductive health care services for service members, DoD civilians and military families. Department of Defense issued a memo to the force, DoD civilians and military families on ensuring access to essential women health care service. The memo reiterates the department will continue to provide seamless access. So basically, is it, summing that all up, really the action they could take is that Congress could codify Roe v. Wade.
Thank you for telling us about those resources. Professor Stone, could you tell us about the EEOC and its relationship with Dobbs and the Pregnancy and Discrimination Act?
Sure. So I'll start by saying that the EEOC is really the specialized agency with the proper expertise to handle a lot of these issues. However, their statements are sometimes used by courts and adopted by courts, and sometimes rejected. So there's a mixed sort of reception when it comes to the EEOC. Case in point. The EEOC concluded before Dobbs that abortion comes under the category of pregnancy discrimination. However, in the case in Dobbs, the court says that that the state's regulation is not a sex-based classification. So there's that tension there initially. The EEOC thus has interpreted the PDA that saying that it prohibits employers from terminating an employee's employment based on her decision to get an abortion. It's also stated that although medical benefit plans need not include coverage for abortions under all circumstances, and I think this was touched on earlier, there's an exception according to the EEOC where the life of the mother would be endangered if the fetus were carried to term, or if medical complications had arisen from an abortion, because that would be pregnancy-related condition, according to the EEOC. And this is from the 2015 EEOC enforcement guidance. Let me just see if I have anything else. Oh, yes. I wanted to add to that. The EEOC has enumerated best practices for promulgating anti-harassment policies. And again, even prior to the Dobbs case, there was always this issue in public workplaces where it was actually more of an issue, and even in private workplaces where some people would allege, I need to talk about my views on this. I need to vocalize how I feel about this. And this is an expression of my religion, whether it's an evangelical religion or just some tenet of the religion that's perceived to require speaking out, versus someone else who will then go to HR and say that they feel bullied or harassed as a result of having somebody either ask questions they're not comfortable with or make statements that they're not comfortable with. So that tension is also something that we should look at when we look at the EEOC's guidance. And I think that that's a very delicate balance, especially in public workplace where employees do enjoy, albeit a conscripted First Amendment right, but a First Amendment right to free exercise. So with that in mind, the EEOC has advised when it comes to religious expression, it's best not to suppress religious expression, but to allow religious expression across the workplace while simultaneously ensuring that nothing rises to the level of actionable harassment. That way nobody feels silenced, especially with respect to his or her religious beliefs. A policy that's promulgated should cover religious harassment expressly, according to the EEOC. It should explain exactly what's prohibited. It should provide an avenue for redress or a mechanism for remedy. So some sort of guidance as to what to do if you are the one who feels harassed, just like with any other harassment policy. And of course, it should be expressly stated that there will be no retaliation for somebody who is reporting harassment. And I think that's important. Let me just see if I have anything else on that. Yeah, yeah, and according to the EOC, again, Title VII would prohibit, just to be clear, adverse employment actions against an employee because of her decision regarding abortion. And this is again per that 2015 EEOC enforcement guidance. So it'll be interesting to see how employers receive this, how these tensions are resolved, and what the courts do with these kinds of situations that arise.
This is great material. Thank you so much. And go ahead, Kelly.
Oh, I was just going to add, because I think we've got a couple minutes left, if it's okay with you guys. Just in connection with what Professor Stone was saying regarding the EEOC enforcement guidance, part of why this guidance is so important to consider, even though sometimes it's in conflict with what the states are saying, or the courts are saying, is that there is an administrative exhaustion requirement for employees who wish to seek relief in court under the Pregnancy Discrimination Act, Title VII of the Civil Rights Act, as well as a lot of the state civil rights laws we were talking about. So for example, under the Florida Civil Rights Act, if an employee wishes to raise a claim alleging employment discrimination, before that employee is able to file that claim in court or submit it through arbitration, that employee must first file a charge of discrimination with the Equal Employment Opportunity Commission. And oftentimes when the EEOC does its investigation, it will rely upon its own enforcement guidance to determine whether there was a violation of a law, rule, or regulation that's applicable. So in this instance, if the EEOC is doing their investigation regarding whether there's been some sort of unlawful discrimination in connection with pregnancy or an employee's wish to seek access to reproductive health care, that guidance will likely be an important factor in the agency's consideration. And likewise, there's deference given by the state the state civil rights agencies to the EEOC. So I think it's definitely important to take it into account. Regardless of the fact that there are some courts that may depart from what the EEOC's conclusions are. And I think, as Professor Stone mentioned, there's also some briefing that's actually submitted to the courts that relies upon this enforcement guidance as just that, as guidance. It's not, binding law, but it still sort of sets a precedent or sort of a floor for, okay, where do we kind of go from here?
That's an excellent point. Exactly right. Yeah.
This is amazing material. Thank you so much. And now we'll open the floor up for questions. If anyone has any questions. I have a question. Do you anticipate any changes in the laws because of Dobbs relating to employment?
I know this is something I've repeated, and perhaps Michele or Professor Stone, you may have a different perspective on this, but I think it's just so early to tell. I think probably in terms of the state laws, you're going to see a lot that reflects or mirrors the positions that are being taken in general regarding a woman's right to choose, access to abortion, healthcare, that the employment laws may look or reflect what those laws have been saying, but that is speculation on my part. And I know we already talked about congressional action. There's already been some movement afoot in some states to grant specific protections for employees with regard to their privacy rights, and to make sure that they're not enforcing out-of-state laws that would prohibit abortions or that would otherwise attempt to prohibit travel to other states. But I don't know that I foresee or any particular federal law, employment law specifically, apart from that. I don't know if the other folks have other insights.
I think I agree with everything you said. I do think it's early to tell. I'm not sure that we'll see anything in terms of new federal legislation. I think the election season is going to be very interesting. And I think we're going to see what legislatures do. And as you said, we see some states moving to curtail and some states rushing to expand. So we're going to see some polarization there in terms of what's allowed, and that will have ripple effects within the workplace for sure. And then it's just going to be up to courts to apply, as these cases are brought about what constitutes, has ERISA been violated in this case? And was this, a justifiable at-will firing, or did it violate some kind of, was it some sort of unjust termination based on common law, based on a statute? We'll see the courts infuse with meaning as they interpret whatever laws are passed, or even just what we currently have.
I have a question that from one of our attendees. It says some states that have criminalized abortion are contemplating making it a crime to assist a person travel out of state to obtain abortion services. Would such state law be legal? What should an employer do if such a state law passed?
So I think I talked about this a little bit earlier. So there's they're referring to them as sort of aiding and abetting laws. And as far as I know, with respect to employers assisting in out-of-state travel and lodging, we have Oklahoma and Texas specifically that prohibit and make it criminally liable, or a party that criminally liable for providing financial assistance for someone wishing to seek an abortion, even if they're going out of state. From what I understand, they've been enacted as existing and good law, or depending on your perspective on the issue, I don't know if you would describe it as good, but existing law. There are other states that also have separate aiding and abetting laws that apply to providers. So I think just really in those circumstances, employers have to be careful, because if they're providing assistance to employees to get that, they could very well be deemed criminally liable in the states that have those aiding and abetting laws.
Well, thank you so much. This has been a pleasure to listen to and very informative. I'm so happy to see you three again, and I look forward to the next one.
We're grateful to be included in this really important discussion. Thank you for letting us participate, and thank all of you.
Yes, thank you.
Thank you so much, and thank you to the American Constitution Society for hosting this for us.